appeals in the matter of Nichols and another, and Mapfre, Espana, Compania de Seguros y Reaseguros, Woodford, Mapfre, Espana, Compania de Seguros y Reaseguros SA, and Sedgwick and Mapfre, Espana, Compania de Seguros y Reaseguros SA.
Thank you very much. Yes, we were sitting in here yesterday and it was boiling hot. I'm sorry, it's quite a lot cooler today. It's really quite cold in here. As you will have heard judges say, up and down the country, can't do anything about what the temperature is, so I apologise. Yes?
Please, your lordships. I appear on behalf of the appellants in this matter, together with Mr. Philip Mead, who sits behind me, and my learned friends, Mr. Chapman, King's Counsel, appears together with Mr. Max Archer, who sits behind him on behalf of all three respondents.
Yeah.
Your lordships will have seen these are the conjoined appeals from two judgments below. First of all, the judgment of Mr. Justice Martin Spencer on the 4th of May 2023 in two conjoined cases on a second appeal where they were joined. Those are the cases of Mrs. Nichols and Mrs. Woodward. And in that judgment, Mr. Justice Martin Spencer dismissed the appeals brought and awarded Spanish penalty interest as a matter of substantive law. He also found Overture that had he had to exercise the discretion under the English statutory provisions for the award of interest, he would have found it wrong to do so by applying Spanish penalty interest provisions.
Yeah.
The other appeal is from the judgment of Mrs Justice Lambert on the 26th of October 2022, that is in the case of Mrs Sedgwick, and in that judgment she also awarded Spanish penalty interest, but she did so as a matter of procedure in the exercise of her discretion to award such interest under Section 35A of the Senior Courts Act 1981, having held first that penalty interest was not an issue of substantive law under Rome II. So in essence, the two respective judgments are the mirror image of each other on the two key issues that are before your lordships. And these appeals appear before your lordships as conjoined appeals pursuant to the permission granted by his lordship, Lord Justice Stuart-Smith, on the 18th of September of last year. The central issues in the appeal can be summarised fairly succinctly, and they are three. Two relate to interest and one to the issue of subrogation. The first issue on interest is whether an award of penalty interest is an issue of substance or procedure pursuant to Rome II, Article 1.3. And I call that issue 1. The second issue, issue 2, is if it is an issue of procedure, whether an English court can or should exercise its discretion to award interest pursuant to either Section 35A of the Senior Courts Act or Section 69 of the County Courts Act by applying Spanish law as to penalty interest. Those two issues, pausing there, my lords, they are of very considerable importance to all parties involved in this type of litigation. As your lordships will have seen, they frequently result in doubling of the damages. That was the case in at least two of these appeals.
Yeah.
And there are a number of cases in which both Mr Chapman and I have been and continue to be involved where the damages are very much more than the damages that appear in the three cases.
On issue 2, is it right to say, pursuant to Section 35A, by applying Spanish law, isn't the issue whether it's right under Section 35A to apply Spanish rates and periods, which is slightly different? Because under Section 35A, you would be exercising the English lex fori jurisdiction you'd be exercising your discretion under 35A. The only question then is it appropriate in the exercise of that discretion to apply the same rates as would be applied by a Spanish court applying Spanish law?
Yes, my lord.
It's a very pedantic quibble, but I think
that's a different framing, but I think we get to the same result in the end.
It may be a matter of, it may not be a matter of substance, but I think it is a matter of.
And what we say is that once, if this court has decided it's an issue of procedure under Rome 2, it is excluded as a matter of or should properly be excluded from the exercise of the discretion. What you, as Mr. Justice Martin Spencer put it below, if you can't get it in through the front door, you don't get it in through the back door. My lords, I was just saying these are issues of considerable importance because of the sort of sums involved, and obviously in the larger value claims, they take longer to get to trial or settlement, and so inevitably the impact is even larger on those sorts of claims. And for that reason, we do not seek to invite your lordships to decide this issue on a pleading point. This issue needs resolving by your lordships, but we reserve our position as to issues of costs that may ensue from the pleading point, if I can put it like that. So we invite your lordships to deal with it on merits, and any other issues on costs or cost consequences can be reviewed later. The third issue is the issue that arises in the case of Mrs. Sedgwick only, and that relates to the issue of subrogation. And that issue is, in essence, which law governs the issue of subrogation and the conditions for the exercise of any rights of subrogation. Is it the law applicable to the insurance contract pursuant to which the subrogation rights arise, or is it the law of the tort under Article 4 and 15 of Rome 2? My lords, may I outline our case, taking issues 1 and 2 together first? May I outline our case on issues 1 and 2 for the court, and then proceed to develop them by reference to, first of all, the principles of interpretation as a matter of European law. Secondly, the instrument of law itself, Rome 2, together with the relevant authorities. And for those purposes, I'll be focusing on decisions of the Court of Justice of the European Union and this court, and not so much courts of first instance. Issue 1 first, then, please, my lords. Our case may be summarised thus. There is a fundamental distinction to be drawn between penalty interest and standard interest. Standard interest is designed to compensate a claimant for being kept out of his money, the damages due to the tort, and to ensure that those damages are fully restitutionary, putting a claimant back into the position that he or she would have been in but for the tort. Contrast that with penalty interest, which is designed to penalise a party, in this case under Spanish law, an insurer, and specifically an insurer, not the defendant, for non-compliance with a given procedural regime. That distinction, we say, was rightly drawn both by Mr. Justice Griffiths in the case of Troke, paragraph 64 of his judgment, and by Mrs. Justice Lambert in the case of Sedgwick under appeal, at paragraph 101 of her judgment, subparagraph 2, that's Core Bundle 196. The penalty applies under the Spanish legal provisions where there has been a breach of procedural requirement that the insurer, not the tortfeasor, pay an interim amount of damages within a certain time after proper notification of the claim. And it is of note, and we say it is clear, that that interest is undoubtedly penal for breach of procedural requirements. The fact that it was penal was accepted by both judges below. That's to say, Mr. Justice Martin Spencer at paragraph 40, reference Call Bundle 174, and Mrs. Justice Lambert at paragraph 81 and 101, subparagraph 2, Call Bundle 192 and 196, respectively. And your Lordships will recall, and I'm not going to take you to it at the moment, that we summarised as best we could the relevant provisions in paragraph 12 of our skeleton argument by reference to several of the first instance judgments, and indeed these judgments before your Lordships, as best we could. But we now have, your Lordships now have, and I apologise that we didn't include it in the original bundles, but your Lordships now have the Act itself, and I'll come on to that in a moment. Perhaps, in fact, I should come on to that straight away, just to reinforce the point I've made. So could I invite your Lordships to take up supplementary bundle, and it's the very first tab. This is the relevant provision, is Article 20 of the Spanish Insurance Contract Act 1980, which appears in translation at pages 1 to 3 of your supplementary bundle, starting at the foot of page 1. Article,
internal pagination.
that is the bundle pagination.
Yeah.
Bottom right of the bundle. Article 20. If the insurer is in default of performance.
Do we have, sorry to interrupt, do we have where the performance is set out, the required performance?
It follows in what I'm going to take your Lordships to now. It's on the following page, my Lord.
Right, thank you.
The compensation for damages will follow these rules regardless of the validity of the contract clauses that are more beneficial to the insured. And then over the page. Generally, it will affect the insurer's default regarding policyholder or insured person, and in particular the default regarding any third parties injured in civil liability insurance and the beneficiary in life insurance. That is not a critical provision for these purposes. 2, it will apply to the delay, and this comes to performance, my Lord, in the satisfaction of the compensation through payment or by the repair or replacement of the damaged object, and the delay in the payment of the minimum amount of what the insurer may owe. And to understand what that is, we need to read on. So subparagraph 3. It will be understood that the insurer is in default when it has not fulfilled its obligations within 3 months of the claim, or has not paid the minimum amount of what it may owe within 40 days from receiving the claim. I'm sorry. And 4 defines the penalty. Compensation for default will be imposed ex officio by the court. It consists of the payment of annual interest equal to the legal interest rate, and pausing there, my lords, that is understood as a matter of Spanish law to be the standard interest rate in proceedings in Spain, in force when it accrues, increased by 50%. This interest will be considered accrued per day with no court claim. However, after
that means without a claim being specified to the court. When it says with no court claim, what's that mean?
Well, I hesitate as I'm not a Spanish lawyer, but effectively the way, as I understand it, and as I understand the evidence that's been before various courts, including the judgments under appeal, there are effectively the claimant, to trigger these provisions, has to provide notice of a claim. Precisely what is required by notice of a claim is not entirely defined by this statute, but it appears to include a summary of injuries and so on and so forth.
And that goes to paragraph 6, which you're coming to in a moment.
And it's...
But I was just wondering, with no court claim, the nearest to sense in English that I can make of that is you don't have to have made a formal claim to the court.
Precisely. And my understanding...
When we get from paragraph 6, you just have to have notified.
Exactly. By letter to the insurer is the standard form.
Can I, as you've stopped now, but if one looks back to 3,
Yes.
paid the minimum amount of what it may owe,
Yes.
do we know what that is?
It's been defined by some of the Spanish law experts in a concession, I think, on one of the experts, I think it was Mr. Sanchez, but we can check that in a moment, as the irreducible minimum. In other words, the minimum arguable value of the claim. In other words, the defendant, as I understand it, the defendant's case on its best day, not the sum which the claimant is seeking to be awarded.
Or indeed, what is then awarded?
Precisely. Precisely. So, I got to halfway through 4. However, after 2 years from the claim, the annual interest will not be less than 20%. So your lordships will see that in a case that takes 4 years to come to trial, the interest racks up exponentially.
And assume
it's not exponential, is it?
Well, a badly chosen word, enormously.
unless you pay the minimum arguable value of the claim.
No, the penalty applies to the whole damages awarded at trial.
Yes. No, I appreciate that, but if you decide to avoid this provision by paying the minimum arguable value of the claim, then you don't
Precisely.
get exposed to it.
Precisely.
If you don't pay the minimum amount within 40 days, but you do fulfil your obligations within 3 months, do we need to understand how that works?
So there are alternative, and I was coming on to that, my lord, which is sub-provision 6. So reading that, the initial term for calculating this interest will be the date of the claim. However, if the policyholder, the insured or the beneficiary, has not fulfilled the duty of notifying the claim within the term, i.e., I presume the term of 30 days, established in the policy or within 7 days of having learnt of it, the initial term of computation will be the day of the notification of the claim. That's a little bit dense to understand. And again, I'm not a Spanish lawyer, and I hesitate. I'm not sure that any of the judgments before your lordships today have gone into an explanation of those initial provisions. But it seems to be clear from the final paragraph that the period from which interest will run is the notification of the claim by the claimant to the insurer. So if it's outside the 30-day period or the 40-day period, and it's half a year after the accident, penalty interest will run if the insurer doesn't comply from half a year after the accident.
I don't think that's what it says. Isn't, forgive me for interrupting so much, but isn't paragraph, the first sentence of paragraph 6, when it says the initial term for calculating the interest will be the date of the claim, the starting point is you take the date of the claim. If they don't notify the claim within the term established by the policy or in 7 days of having notified, the initial date of the computation will be the date of the computation of the claim. Will be the date of the notification.
Notification of the claim. So if no claim is issued within the period, but a claim is notified after 6 months by letter to the insurer, as I understand it, the interest runs from the date of, if there's been non-compliance, the interest runs from the date of the letter, the receipt of the letter. And in fact, in one of these cases, I think it's in the Sedgwick case, but I'll be corrected if I'm wrong, that can be seen in how the interest was actually awarded. It ran from the date on which the letter of notification arrived. And then those provisions are followed by the final paragraph of 6. As for the injured third party or his heirs, the first paragraph of this section will be accepted when the insurer proves that it did not know of the loss before receiving the claim or the victim or their heirs exercising the direct, in which case the date of such claim or the direct action will be the initial term. And that, again, is not the easiest passage to understand, but in a sense, this highlights one of our submissions, and I'll take your lordships to passages in the judgments of this court which make the point that the reason why we have a rule that issues of procedure are a matter of English law in claims brought in England is that it is difficult for judges and courts in this land to understand procedures that may be a combination of statutory provision as subsequently interpreted by decisions of the Supreme Court in Spain or other courts in Spain, and the procedures there to then apply penalties to foreign procedures. And this is an illustration of how difficult it is when the court is being asked to apply penalties which apply to breaches of foreign procedures. And then I think the only other relevant term of is 8 of Article 20. There will be no compensation or delay by the insurer when the failure to pay the compensation or to pay the minimum amount is based on a justified cause or is not attributable to the insurer. And in essence, my lords, what we say is it is clear from this statute that this is a penalty applied to an insurer, not the tortfeasor, for breach of following rules of procedure as to payments of minimum amounts of value of claim within certain time limits. And your lordships will bear in mind that in this particular case, my client on all 3 appeals is a Spanish insurer, but that's not always the case. Sometimes it is an English insurer. If, for example, one has a motor vehicle and it's a number of people travelling in an English car, you might easily have an English motor insurer who's then being expected to comply with Spanish procedural provisions with which they'll be completely unfamiliar.
But this is really just requiring early interim payments.
It is.
English insurers are well able to do. And if you're talking about the big value claims, become even more important.
It's more than an interim payment, my lord.
Yeah.
Because an interim payment is just a sum on account. This requires an insurer to be able to value the claim at an extremely early stage and value it realistically. In complex cases, that is not an easy thing to do.
Did you say that this might apply to an English insurer who wouldn't know about the provisions. Well, surely any self-respecting English insurer who's going to issue insurance which is going to cover people in Europe ought to know about this.
Well, they certainly won't be. They will have, if the decision of this court is that it's not an issue of procedure or it's an issue of procedure which should be applied, then they will have to be. But in my experience, that there are some insurers who are not familiar. Now, that may be an issue of criticism. I accept that, my lord. But they're obviously not going to be as familiar with it as Mapfre.
Well, these cases have been kicking around since Rome II started.
They have, my lord.
So if they're not aware of it now, then I entirely accept that may be your experience, but whether they're well advised is an entirely different matter.
I accept that, but as your lordship will have seen, there are a number of decisions going different
Both ways. Yeah.
And that's why this needs sorting out by your lordships. My lord, can I then come back to the outline of my submissions, having taken your lordships to the statutory provisions as a matter of Spanish law? So we say that on a proper construction of Rome II, drawing down on the fundamental distinction between standard interest and penalty interest. Standard interest is a matter of the substantive law within the meaning of Rome II because it is part of any restitution to put the claimant back into the position they would have been entitled to. It is interest designed to compensate a claimant for being kept out of the damages for the period that happened. By contrast, and to that extent, pausing there, it may help your lordships now to know that, unsurprisingly, therefore, we have no issue with the decisions in a number of the authorities on which the respondents rely, principally Mayher, the decision of this court in Mayher. But they were all dealing with standard rates of interest. They were not dealing with penalty interest. And but insofar as the respondents refer to decisions which go their way at first instance following Mayher in the context of penalty interest, we say that those decisions, those courts fell into error either by failing to acknowledge that Mayher was pre-Rome II and post-Rome II a different legal framework must apply, and or by failing to draw a distinction between standard and penalty interest, which is a distinction of substance, save for the decisions of Mr. Justice Griffiths in Troke and Mrs. Justice Lambert in Sedgwick. By contrast, my lords, an award of penalty interest for procedural default by an insurer is not a matter of the substantive law within the meaning of Article 4 and Regulation 4 and Regulation 15. And here it's principally Regulation 15C on which the respondents rely, as I understand it. But we also will come to look at 15A and 15D. Because, and this is a key part of our case, it forms no part of any restitutionary compensation.
Can I just make sure I've got what your submission accurately? So you accept that you get your Baremo damages and then you get your standard interest, assuming that there's been no relevant defaults, or if they are, they're all justified. And those are calculated according to Spanish rates of interest.
Yes, Spanish legal interest, as it has been called,
3%, 4%.
Doesn't depend on any procedural. That is there as a matter of right, and it's part of the restitutionary award, and we accept that as a matter of Spanish law.
Right.
But all three cases before this court, we say they're different because in each case there was an award of penalty interest under the Insurance Contract Act. And that is different in substance and not a matter of the substantive law.
And what about the fact that the Spanish interest rate is set according to Spanish conditions, whereas our inflation rate may be much lower and, at different times will be not compensating, but actually overcompensating the claimant kept out of money?
Well, that may be an unfortunate consequence, but what we say is that Rome 2, it is what it is under Rome 2, and there is a clear dividing line, and the way Rome 2 is worded and the context and the objectives of Rome 2 make clear that the applicable law applies to both the restitutionary award and how it should be assessed under Regulation 15, but not to a penalty applied to an insurer for failing to comply with some procedural provisions, because those are issues which don't arise out of the tort. They're not consequent on the tort, and they're not designed to put the claimant back in the position he would have been but for the tort.
And again, sorry to ask, but then I got it out of the way. There were sometimes perceptions, I mean, one knows from previous practice, that Spanish awards were low, and this was just part of, in some respects, balancing out the what we might have considered mean awards for the loss and damage.
My submission is that is an impermissible use of the law.
Thank you.
My lords,
It's a very narrow point, because the distinction you draw is between standard rate, which you say, if I've noted it correctly, is designed to compensate the claimant for being kept out of his money, and penalty interest, which you characterise rather differently, in accordance with your case. But at one level at least, it is designed, the penalty interest is designed to compensate the claimant for being kept out of his money. He should be paid his money within 20 days, 3 months. If he isn't, he gets compensation for the fact that he's not. And it's called enhanced interest.
it's not restitutionary compensation, my lord.
Well, it's not restitutionary, but in the sense that you say it gives him more than the value of the cost of money going out. But it's compensatory.
I don't accept that, my lord. My submission is it is a penalty.
Well,
What is compensatory?
And in one sense, I completely agree with you. It's expressed as a penalty in the articles and so on and so forth. But if you, it may be the reason why we simply have to look at Article 15C and see whether it's part of the assessment of damages or assessment of the remedy, which arguably it is, rather than trying to impose an English straitjacket of, so that, I mean, which I find very helpful in many ways, because I'm not sure I understand the Spanish law at all. But what you're doing is you're applying an absolutely English prism to what the Spanish law does.
With respect, my lord, I'm not, and it's because I haven't come on to the next part of my argument, but I will. The way we put our case is that applying proper principles of interpretation of European law, which disregard national principles completely, on a proper construction of Rome 2, this is a distinction made. And that is because Regulation 15, well, read in conjunction with Regulation 3, Article, makes quite clear that the assessment of damage and what is to be decided as a matter of the substantive law within Regulation 15 is restitution. Penalty interest is not restitutionary. What is restitutionary is standard interest. If an insurer keeps delaying and delaying and delaying, the interest continues to run, and the claimant is put back in the position that he or she would have been in but for the tort. Penalty interest adds more, and adds a great deal more. And it is designed not to compensate the claimant under principles of restitution, but to penalise the insurer, to encourage all insurers to achieve procedural goals, That is, early settlements of cases. That is the key distinction which we invite this court to draw, not as a matter of English law, but as a matter of European principle.
Could I just ask, you said that penalty appeared in Article 20. Where do we get that? Or perhaps I misunderstood.
Did I say it appeared in Article?
Well,
You did.
I'm sorry. I may. If so, what I meant is in the evidence as to the Spanish law expert evidence.
Right.
The experts describe it as penalty.
right,
interest.
because the Act describes it repeatedly as compensation.
That's correct. The experts, and we can look at some of the joint statements in due course. Yes. Well, insofar as it refers to compensation, my lord, it's, for example, subparagraph 4 of Article 20.
Well, the whole article is compensation for damages.
Well,
Will
Article
follow
4
these
is compensation for default.
No, the article, if the insurer is in default of performance, the compensation for damages will follow these rules.
Yes.
And then these are the rules, and as we see at 4, it's compensation for default.
Yes.
If you don't make the payment of the irreducible minimum.
Yes. But, my lord, the principle is that in deciding whether this is an issue of procedure, the way Spanish law defines it is immaterial. It is an issue of European law.
But
it is only to Rome II that we look.
Yeah.
But you're about to take us to the Spanish law experts who say penalty.
It's
Don't worry, I mean,
that's a fair point. That is a fair point.
It would also be a fair point if my lord had said you've taken us very carefully through the English approach to it, which is also relevant because it is a matter of European law.
That's also a fair point, but I've taken you to the English approach to it. I've taken you to the English approach because, of course, this court is dealing with 3 English appeals, which have been dealt with at first instance by judges trying to do their best in difficult circumstances. But I am not relying, as I made clear in answer to your lordship's earlier question, I'm not relying on what view English law has of these matters. I'm relying on a proper construction of Rome II.
Thank you.
My lords, we say, in short, it is under Rome II an issue of a matter of procedure within the meaning of Article 1 and 3, and therefore governed and governed only by the law of this forum. May I turn then to issue 2 to outline my submissions before then developing these arguments. That is, if it's an issue of procedure, can and should this court exercise its discretion by the application of Spanish rates under the Insurance Contract Act, if I can put it neutrally like that, rather than penalty rates. If, and what we say is this, if it is an issue of procedure, it is wrong in principle, under Rome II and the proper construction thereof, to exercise the discretion to award interest under English law by applying foreign procedural provisions. The English discretion must be exercised consistently with Rome II. And to that extent, the discretion since Rome II has become fettered by Rome II in any case to which Rome II applies. Therefore, insofar as interest is awarded as a form of compensation to compensate a claimant for being kept out of his money, substantive law applies. But when it comes to penalties for procedural default, the lex forum applies. In other words, it's our Part 36, it's not Spanish or Greek or German And that is because Rome 2 stipulates that the scope of the substantive law, and we'll come to Article 1.3 in a moment, shall not apply to issues of procedure. And that provision will come to see as a provision intended to enshrine what had already been the universal principle of private international law, that matters of procedure are matters to be governed by and only governed by the lex fori. And we further say that it is wrong in principle for an English court to award penalty interest here, as if the proceedings had been brought in Spain, because they were not. Penalties for procedural default should be measured in cases brought in this jurisdiction by the measures, the procedural measures that we have in this jurisdiction, not by foreign ones. The claimant chooses to sue here, knowing that the lex fori applies to all issues of procedure and only the lex fori. And in that regard, we say that Mr. Justice Martin Spencer was spot on at paragraph 40 of his judgment. That's Core Bundle 174. And we also say that that submission is supported by the judgment of Lord Justice Floyd in this court in the case of activists, which I'll take your lordships to in a moment, albeit overture, and also Dicey at chapter 4, paragraph 002.
So when you said, sorry to interrupt you, when you said that, making this contrast, and you said, well, penalties for procedural default, that's our part 36. That's obviously concerned with offers.
It's...
I mean, that's what part 36 is concerned with.
Indeed.
I mean, that's not a code for penalties for procedural default. It's a particular provision that applies in cases of offers and whether or not offers were beaten.
It's our equivalent in the sense that it is a procedural regime which encourages parties to settle cases early and then applies penalty provisions in circumstances where there has been inadequate compliance. Or
you may have to develop that equivalence because at the moment I don't quite see Part 36 as being the equivalent of.
I'm not submitting their ad idem at all. No. But what I am submitting is, for example, taking it at its simplest, in two of the cases before your lordships, Spanish penalty interest was applied, and then Part 36 penalty provisions were applied. And those provisions include penalty interest.
That's, as my lord says, they're triggered by different things. We don't have what you would describe as procedural code for dealing with the simple fact that a claim has not been settled sooner.
We don't have a code which says that insurers must make an interim a good value offer within 30, 40 days.
A minimum amount.
We don't have anything like that.
We don't have anything like that.
We don't.
This is a minimum amount. Whereas the interest that applies in relation to Part 36 is you haven't offered enough.
I accept that, my lord, but I'm not.
So
I'm not
a penalty for a different thing. One is delay, not making any payment at all, and the other is not doing your sums right.
If your lordship understood me to say they were equivalent, I didn't mean that in the slightest. No. What I mean is we each have our procedural regimes. Within those procedural regimes, there are certain provisions which are there to encourage insurers to settle claims and claimants to settle claims early, and then subsequent penalties are applied. It is wrong in principle and contrary to Article 1.3 of Rome 2 to allow a situation whereby two sets of procedures can be applied.
Can we safely assume that Spain doesn't have anything remotely equivalent to Part 36?
I hesitate to answer that question,
well,
but I'm not aware of any. I'm not aware of any. And
But we should proceed on the assumption that there isn't. At this stage, at any rate. If we accede to your suggestion that we deal with the merits but leave questions of costs over, then different considerations might apply and people may do further research.
yes. My lord, I'm not aware of any such provisions.
So this point actually boils down to a slightly simple point where you say, well, it's wrong in principle to have two different, as you have them, sets of procedure applied to the same case.
Yes.
I understand that.
Could you just tell us the paragraph number of Lloyd Justice Floyd's judgment in activists that you referred to? You said he referred
It's
to...
paragraph 132. My lord.
Thank you very much. Sorry for that.
I'm going to take your lordships to it shortly.
It's always the problem when you outline your submissions and
We want to start
you have you have two Lord Justices of Appeal absolutely straining at the leash. So we'll do our best not to interrupt you too much, but I hope it's apparent from the questions so far that we think we're reasonably on top of the kit, and we think it's an interesting and important point. So if that's some consolation, I offer.
My lords, I welcome healthy debate, and I am taking all interventions and questions in that context. It is a fascinating area.
And I may come to regret calling it an interesting point, but let's carry on. All right. So are you still outlining your case on issue 2?
No. Essentially, I've just made the last point as a consequence of your lordship's intervention, which is that the purpose of Article 3 is to ensure that only one set of procedural rules applies, and that is to achieve consistency and uniformity across Europe. Now, my lords, may I develop the arguments in this way? First of all, by reference to the principles of interpretation of instruments of European law, and I will, as I do so, take your lordships to relevant authority. And then secondly, by reference to the context and the language of the Rome II regulation itself. My lords, as to the proper approach to the interpretation of instruments of EU law, or European Union law, there's relatively little between us, save where it comes down to the application of a narrow or wide construction to certain provisions of Rome II, and I think that's stripping it back to its bare bones, the essence of the dispute between us. So I hope I can take and I know this court is more than familiar with these principles, and I'm going to take them at a little bit of a canter, but please do intervene if I'm going too fast. So the first point is that whether an issue is one which falls within the scope of the applicable law under Rome II, as opposed to one of procedure to which Rome II does not apply, is itself an issue of European law and therefore subject only to European law canons of interpretation. The following principles apply, and for your lordship's note, this stems from paragraph 10 of our skeleton argument. The principal canon is that the terms used should have a uniform autonomous meaning and a uniform sphere of application. And the fact that a rule is classified as one of substance or procedure under a domestic law has no relevance. The second principle is that it is necessary to consider not only the wording of a European instrument, but also the context in which it occurs and the objectives pursued by the rules of which it is a part. And at that point, if I can ask your lordships to take up the authorities bundle, I'm going to take your lordships to both activists, but first of all, Lazar. And that is tab 8. In order to Are all your lordships using hard copy, not electronic bundle?
Well, I've got both.
If you like the I can give your lordship
Yeah,
the
it's very
electronic
helpful to
bundle
have
as
the-
well as I go through it. So, my lord, Lazare first. It's really just one paragraph, and it's paragraph 21. But to set the scene, my lords, you may recall this was a case involving a Romanian claimant who brought a claim in Italy, a fatal accidents claim, because tragically he lost his daughter in a road accident there. Italian law was the applicable law, under which damage suffered by a family member is to be regarded as having been suffered directly by another family member. And the Italian court in that context referred a question to the Court of Justice of the European Union as to whether harm which the father had suffered personally as a result of the death constituted damage, or whether it was an indirect consequence of the tort within the meaning of Article 4.1. And it's not so much the decision in that case as the observations in relation to interpretation of Rome 2. So without further ado, if we could turn to paragraph 21, and having said that, it's one of the ones I seem not to have, but I will find the electronic. It's on the penultimate page of the. Your Lordship just gives me a moment. It's electronic bundle, page 160, my lord.
Thank you.
And if I could just invite your lordships just to read that paragraph, please.
Paragraph 21.
Just 21, my lord.
Yeah.
My lords, can I then take you, please, to the case of decision of this court in the case of Activist UK Limited against Eli Lilly, 2016, For All England Reports at 666. It's tab 7 of the authorities bundle. And for my Lord Justice Dingemans' note, the electronic bundle page references are at page 134.
Thank you.
It's paragraphs 130 through to 139. But before we get there, just a little bit by way of background, if I may. So the leading judgment was Lord Justice Floyd, and Lord Justices Longmore and Kitchen both agreed. The decision was overturned by the Supreme Court on different grounds, but not on any grounds concerning the issues of interpretation of Rome 2. It's clear, and I needn't take your lordships to it, that the discussion on Rome 2 was obiter, given the way that the decisions were taken on other issues, and the claim involved declaration, a claim for a declaration of non-infringement of patents. And the issue was whether the rules which applied to the obtaining of such declarations were matters of procedure or substantive applicable law. And then, so if your lordships turn to paragraph 130, which is on page 698 of the report. Picking it up at the bottom of the page, discussion and disposition. First of all, Article 1.3 of Rome 2 is a rule about what is sometimes called the vertical scope of the regulation. Evidence and procedure are excluded from the scope of the regulation, although it does not automatically follow that these issues will be subject to the lex fori. The private international law principle that such matters are for the law of the forum is well recognised. It is enough to quote Dicey at 7002. The principle that procedure is governed by the lex fori is universally admitted. And as well see, that principle was taken up in the Travo prior to the enactment of this European instrument. The next passage, would it be more helpful if I left your lordships to read, please, 131 through to the end of 134, and then 139.
Well, 135 is relevant as well, isn't it?
Sorry?
135 is relevant as well.
I'm happy for your lordships to read those 2 pages, my lord.
Yeah, let's do that.
Down to 139, please. May I also invite, while we're here and to avoid coming back to it later, over the page at 142, please, my lords. And this concerns interpretation of 15C.
Was this reasoning approved by the Supreme Court?
The appeal to the Supreme Court didn't concern Rome 2, so but I would need. May I check that?
Of course, it's just for my notes. I entirely accept what you say. They didn't trespass on it.
If I can come back to you on that.
Can you just help me on page 704 of the report?
704.
Of the report.
Yes.
At the end after the judgment, it says that the Supreme Court refused permission to appeal. Did they think better of it?
I'll need to check that as well. I had thought that.
Sorry,
I
you did
confirm matters after the short judgment. My Lord, may I just make 2 points? At paragraph 132 of this passage of the judgment of Lord Justice Floyd, where he finds the distinction, a fundamental one, and goes on to say that the principle underlying that distinction is that a litigant cannot expect to occupy different procedural position to that of other domestic litigants. We say that is an important point. And secondly, the passage at 142, I'm going to pick up on that because it's a point taken up in Plender and Wilderspin, the language used in other language versions as to compensation, indemnity or reparation in the context of 15C. My Lords, pausing there on the, well, please keep the authorities bundle in front of you, but I'm moving forward to the next proposition of interpretation. The next proposition is this, that the answer to interpreting any particular issue or concerning this regulation is to be had by interpreting the language, and in that context, the language should be given their natural meaning. And in this context, and this is where we begin to part company, the respondent and the appellant, the words evidence and procedure, we say, should be given their natural meaning, not a narrow meaning. And for that purpose, I'd like to take your lordships to the decision of this court in Wall and Mutuel de Poitiers. My Lords, that's tab 4, and the key passages in this regard, insofar as electronic bundle page references, my Lord, are pages 70 to 71 of the electronic bundle.
Thank you.
Before I take you to the judgments of Lord Justice Jackson and Lord Justice Clark, as well as the judgments of Lord Justice Longmore, I know this is a decision with which all of your lordships are more than familiar, and so again, may I canter through the background. The issue before the court, it was a claim in which French law was the applicable law. The leading judgment was given by Lord Justice Longmore. Further judgments were given by Lord Justices Jackson and Clark, but they both agreed with Lord Justice Longmore. The French law was the applicable law, and the argument was concerned the proper interpretation of Articles 1, 3 and 15C and D, more in relation to what was an issue of evidence, because the issue that came before the court was whether, as the defendant contended, the court should restrict permission for expert evidence to one court-appointed medical expert, which was the system in France, or whether the court should allow the usual array of relevant medical experts that we see in this jurisdiction. the claimant wanted the usual, as happens in this jurisdiction, the defendant was contending for one court-appointed expert. If, can we pick it up, please, first of all, in the judgment of Lord Justice Longmore, at paragraph 15, and in a section paragraph 11, I'm sorry, in a section, this is page 426A of the law report, section entitled Same Result as in France. I haven't immediately got the electronic bundle page ready.
Don't worry, I'm following.
Thank you, my lord. And can I invite your lordships now to read 11 through to 16 at the foot of the next page. My lords, this mirrors the argument presented by the respondent in this case, that the same result should happen here as would happen in a case brought in Spain. At paragraph 11, another aspect of the argument that mirrors the respondent's argument is that Mr. Brown relied on certain recitals, particularly recitals 6 and 14. Those are relied on, exactly the same recitals relied on by Mr. Chapman in this appeal. And ultimately, the Court of Appeal found outcomes will be different. That is an inevitable consequence. In this case, in relation to evidence, in our appeal, we say exactly the same in relation to procedure.
But that presupposes that you're right that it's procedural.
Yes.
I mean, I regard Wall as a complete full toss down the leg side, in that it was to do with expert evidence and whether you had a single expert or, as we have, multiple experts. I mean, you couldn't get more evidence and procedure, a point of evidence and procedure, and therefore you couldn't. Clearly, there will be differences as a result of those differences. Clearly, that won't mean that you will necessarily get the same result. So I understand all of that. So you're right in that it mirrors the result for which Mr. Chapman contends, but I'm not sure, speaking for myself, that I derive much assistance from this because it's difficult to see how the other argument could have won on the facts of war.
I'm certainly not seeking to draw a factual analogy.
No.
We're in two different camps. It's evidence and procedure, and we're in the procedure.
Yeah.
And I accept that each case will be determined on its facts. But the reason why I'm putting this decision before your lordships is that it did involve a proper construction of Article 1.13.
Yeah.
And the submission that should be narrowly construed was rejected. And may I now take your lordships to the judgment of Lord Justice Jackson, which we pick up at paragraphs 33 to 34, and those were the electronic bundle references that I gave your lordship a moment ago. No, I'm sorry, not 33, I mean 40, so under 39 onwards, section 2 of the judgment, the meaning of evidence and procedure.
Oh, yeah.
I'm sorry. And can I invite your lordships to read from 40 through to the end of 43, please, halfway down the next page.
39 to 43.
Please.
Thank you.
And my lords, the point made in the last of those paragraphs is a point which we say, I've made it already, but we say, I draw support from this passage of Lord Justice Jackson's judgment. It applies equally forcefully to issues of procedure.
But compensation should be the same, so that the loss of an arm isn't valued as we would value it in England. You have to value it as in Spanish law. When you've got
all forms of restitutionary compensation, yes.
Yeah.
My lords, can I then take you, please, to tab 1, Rome 2 itself?
So those are the submissions on principles of interpretation of European law.
Yes.
So we're now moving...
Whilst taking you to them, I hope I've sought to take you to those passages of the judgments which relate to specific provisions of Rome 2, which
Yeah.
I'm going to revert to, take your lordships to now.
Thank you very much.
It's tab 1 of the authorities bundle. The first point we make, my lords, is the title of the regulation itself is a regulation on the law applicable to non-contractual obligations. And this is a theme which is taken up throughout the regulation. If we turn forward 4 pages to chapter 1 after the recitals, and start with chapter 1 scope, article 1 scope. This regulation shall apply in situations involving a conflict of laws to non-contractual obligations in civil matters. Pausing there, penalty interest for procedural default does not relate to the tort.
if it was compensation for procedural default, would it?
If it's restitutionary compensation.
So that's really the difference between the two of you.
I'm sorry to be so stupid. You placed very great weight when you were reading it on the word obligations. Can I ask you what you mean by that?
My submission is this is a reference to the tortious obligations, and it's to be read in conjunction with the other passages which I'm going to take your lordships to.
Okay.
But this
So
phrase,
that takes you to the primary question of liability, whether A is liable to B, and as far as the next question, which is the heads of damage which are recoverable under the law of the lex causa, but beyond that you do not go.
and precisely, save insofar as Rome 2 specifically provides for other matters in Regulation 15, my lord. Lord, we then go to 1.3, which is the key provision in the next column. This regulation shall not apply to evidence and procedure without prejudice to Articles 21 and 22, and for your lordship's notes, Article 21 relates to formal validity and Article 22 to burden of proof. Now at this point, my lords, we do draw your lordship's attention to the Travo for context and objective. The Travo themselves are not in the bundle because the citations we put in the skeleton argument are not disputed, and it's understood that I understand that the learned friends do not wish to put any other aspects of the Travo before your lordships. They can be produced if required. But we cite the relevant passage in full, and it's paragraph 12A of our skeleton argument at core bundle 55, please. Yes, the paragraph starts at the foot of 54 on the previous page, and then is broken down into the Travo insofar as they relate to 1.3, 15C and 15D. And to avoid jumping around, can I simply invite your lordships to read paragraph 12 of the skeleton? I can invite your lordships to leave that page open. So if we go insofar as I was making submissions in connection with Article 1.3 of the regulations, the important passage of the citation there is that the intention is to adopt the then existing universal principle that the law applicable to procedural questions is not the law governing the substantive legal relationships between the party, but rather the procedural law of the forum.
May I ask just one question on your 12C, that bit?
Certainly.
Because when I was reading it before, one analysis, and maybe the wrong analysis, of the Law 5080 is that it is a way of halting the damage. What would you say about that? Because you halt the damage by getting everyone to sort of reconcile early.
I don't see, you don't halt the damage by, that's a procedural mechanism, my lord. You're simply, if that is the aim, that is a procedural aim.
Right, okay, that's fine, I understand your answer. I mean, just so to give you an opportunity of dealing fairly with it.
Yes.
I mean, you can never, once you've lost your arm, you can never get it back again.
No.
But halting the damage, as I'd understood it in European concepts, was very much in relation to restitio in integrum, so that you actually give them the money back that equates to it. So the earlier you get that, is the earlier you halt the damage. That was my understanding or misunderstanding of that passage.
If that passage also goes on to talk about interlocutory injunctions and so on, which is obviously a different situation to the one that your lordship is envisaging. But I think where we would stand is that if and insofar as that is an aim to achieve complete restitution as early as possible, the as early as possible is an issue of procedure, but complete restitution is an issue of substance.
Thank you.
And my lords, we've already seen that in relation to 1.3, the argument that Article 1.3 should be construed narrowly was rejected by this court in Moral Mutual. Article 2 next, please, my lords, non-contractual obligations, and this comes to the article relevant to my Lord or Justice Stuart-Smith's question a moment ago. For the purposes of this regulation, damage, and this is important because it defines damage for the purposes of Rome 2, shall cover any consequence arising out of the tort or delict, unjust enrichment, negotiarum gestio, or culpa in contrahendo. For our purposes, arising out of the tort or delict. And so by this article, damage is confined to any consequence arising out of the tort. Penalty interest or procedural default forms no part of that definition of damage. Standard interest would.
Why?
Because it is part of restitutionary damage. It arises out of the tort.
You don't get that from Article 2, surely, because all this is saying is that where you find the word damage in the regulation, which we will see again when we get to 15, it covers a consequence arising out of the tort.
I beg to differ. I mean, it may be that they're read in conjunction, but even on Article 2, I would say you do get that, because the words damage shall cover any consequence arising out of the tort. The consequence is the fact that the damage is to put, tortious principles require the tortfeasor to put the claimant back into the position that they would have been in but for the tort.
damage is the thing that has to be remedied.
The damage has to be...
So the damage is the loss of the arm, whatever it may be, loss of earnings, it doesn't matter what it is. That's the damage, and that is what has to be remedied, and that's what that is saying. It should cover any consequence. The consequence arising out of the tort delit is not restitutionary damages. It is the consequences that by one means or another, however these are going to be interpreted, needs to be compensated or brought into account.
We may be at cross purposes, my lord.
We may be.
My submission is that insofar as Article 2 defines non-contractual obligations, damage, insofar as it is defined as shall cover any consequence arising out of the tort, and certainly we need to interpret this in conjunction with all other relevant provisions of Rome 2, and I'm coming on to Regulation 15 in but it only is intended to encapsulate restitutionary damage arising out of the tort.
Okay. Well, you have a broader view of this than I have at the moment, but just looking at Article 1, my provisional view, just in case it's of any interest, is that damage is that which falls to be compensated,
Yes.
not the compensation itself. But
I follow.
I may be wrong, but that's where.
Now I think about that.
Yes, of course.
Thank you.
Well, if you think it's worth thinking about.
Certainly is. Been thinking about all these issues for quite some time. My Lord, we then turn to Article 4 over the page, if I may. Chapter 2, Torts, and Article 4, General Rule. Unless otherwise provided for in this regulation, the law applicable to a non-contractual obligation arising out of a tort shall be the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage has occurred, and irrespective of the country or countries in which the indirect consequences of that occur. Again, the only point I make in relation to Article 4 is similarly, it is defining the law applicable to the non-contractual obligations arising out of a tort, a recurring fee. But can we then move to Article 15, please, which is a couple of pages forward, under Chapter 5, Common Rules. And Article 15, as your Lordships know, defines the scope of the law applicable. And it begins in this way: the law applicable to non-contractual obligations under this regulation shall govern in particular, and here it is defining a list of certain aspects which will form part of the substantive applicable law. So A, the basis and extent of liability, including the determination of persons who may be held liable for acts performed by them. B does not concern us in this appeal. C and D do. C, the existence, the nature, and the assessment of damage or the remedy claimed. And D, within the limits of powers conferred on the court by its procedural law, the measures which a court may take to prevent or terminate injury or damage, or to ensure the provision of compensation. And just picking up on the question that I was asked by Lord Justice Dingemans a moment ago, insofar as the objective is to terminate the damage quickly, it's interesting to note the way in which 15D is framed, because it is prefaced by within the limits conferred on the court by its procedural law.
Can I then just deal with you? Suppose you're right in everything you've submitted so far in relation to this being a matter of procedure. The procedural law limits that would prevent us dealing with matter, or that would then govern us, are 35A and 69. And those aren't limited to prevent us from dealing with the consequences of terminating damage, or will you'll deal with that later on in your argument, will you?
What I say on that is that Rome 2 does, I accept your point, but Rome 2, if you decide this is an issue of procedure, under Article 1.3, it's excluded from the substantive law. Shall not include. So those provisions of Spanish law, which are issues of procedure, are out and not to be brought in by the back door of Section 35A or Section 69.
The Mr. Justice Spencer point, yeah.
Precisely.
Thank you. Sorry to have interrupted
Not at all.
just while we were on here.
My Lords, in relation to C, the existence, the nature and the assessment of damage, of course, we've just seen how that has been defined in the previous article. or the remedy claimed. And this is the provision on which I think the respondents, as I understand the submissions, focus their fire. And I've taken your lordships already to the relevant paragraph in the Travo, that's to say the explanatory memorandum set out of the Commission, set out at paragraphs 12b. And the words of that are interesting. The objective is to determine the damage for which compensation may be due. And can I pick up then and
The
take
same
your-
word as in the Act.
But the Act is irrelevant.
Well, I understand that.
How Spanish law
I know
defines it
that.
is irrelevant.
I know that. It's just quite interesting that civil lawyers, both the EU and the Spanish, are both using the word compensation.
Indeed. And it doesn't make it any easier for us or your lordships. I quite accept that. But can I take your
Sorry,
lordships?
just before you left, which specific provision were you reading there?
I was reading from 12b of the skeleton, core bundle
the
55, my lord.
Thank you very much. Yeah.
Can I take your lordships then to a few...
Well, are you leaving Article 15?
I'm coming back to it, but I'm taking
Okay.
you to
The
some
leash is-
academic
the leash is being
commentary by
strained,
Richard
being-
Blender.
The leash is being strained, but at the moment I am restrained.
Well, I'm happy to let your lordship off the leash if...
Oh, I wouldn't do that. Is the argument as simple as this? That although the penal interest can be said to form part of the assessment of the remedy that is claimed, because it is procedure, it is excluded by Article 3. Full stop. End of argument.
I think I put it slightly difficult.
Because
Different.
the reason why I put it like that is that at the moment, I would think it may be difficult to say that what we're talking about, namely the interest that is applied and comes out as part of the end result, is not brought in as part of the assessment of the remedy claimed. For the reasons which I picked up with you a moment ago, I agree it's not assessment of damage. And this is one of the reasons why I picked you up on it a moment ago.
Yes.
But just giving the words their normal meaning in isolation, but in the context of Article 15, it seems at least arguable for Mr. Chapman to say what the penal interest forms part of the assessment of the remedy, because the remedy for the tort ends up with the final judgment or whatever it is, determination. In which case, am I right in understanding you say, even assuming for the purposes of argument, which just please do for a moment, that that's right, the regulation doesn't apply at all, and so 15C doesn't apply, because this is a matter of procedure and thereby excluded by Article 3, or have I misunderstood the argument?
You understood it entirely.
Okay.
But I part company on whether it falls within the definition of remedy. And that's why
Yes.
I'm going to take your lordship to Blender.
Okay, but anyway, that's the, as it were, the battle line.
Yes.
Thank you.
Can I then invite your lordships to turn to tab 17 of the authorities bundle, please? This is electronic bundle page 369 to 370, my lord.
Thank you.
And this is Blender and Wilderspin on the European Private International Law of Obligations, 6th edition, as you'll see from the first page of that tab.
Forgive me, I was making a note of your immaculate submission and I missed the reference. Can you
Tab
tell me?
It's tab 17, my lord.
Thank you.
This is Blender and Wilderspin's 6th edition of the European Private International Law of Obligations, 2023. And the passages to which I'd like to refer your lordships are at 16, and so this is about half the way through the tab. Unfortunately, this text, this print off, is not paginated, but it's a page headed up Article 15C, Damage and Remedy.
Yeah. Just after footnote 208.
Thank you, my lord. Do all your lordships have that page? I'm grateful. The passages that I'd invite your lordships to read are essentially the second section, interpreting Article 15C textual differences. So if I can invite your lordships to read the whole passage, please, down to the next section, halfway down the next page.
The difference between damage and damages is fundamental. As a common lawyer, the difference between damage and damages is fundamental. You can't begin to deal with any point under the Civil Liability Contribution Act without that difference well in mind. So the first two paragraphs are suggesting that it should be damages, not damage. Is that right?
Well, he backs off in 1631.
Yeah, well, it's a pretty fundamental typo, if that's what it's supposed to be. Anyway. So this is now paragraph 16032 is the point about remedy.
Yes.
So this is what you'd like us to...
Well, it's also that 1631 is important because the different language versions all refer to the concept of damage in the sense of loss sustained.
Yeah. There we are. I see compensations back.
It comes back in definition, insofar as remedy is concerned.
Yeah.
And we would ally ourselves with this commentary that these versions therefore refer to a remedy which is designed to put the claimant back into the position he was in prior to the defendant's wrongdoing. Restitutionary, no more, no less.
But like so many, it doesn't actually give us an answer. It tells us there's a problem and doesn't. There's no authoritative answer.
Not even Dicey gives
no,
your lordships an
These
answer.
passages of Dicey are absolute nightmare. They're full of not necessarily so. Well, that's personal view. There is no authority. Well, sorry, the question I was going to ask is the English language version an authoritative version?
All language versions can be taken into account equally. Most regulations are drafted initially in the English language and then translated, but all have equal weight and must be weighed into the balance.
I think in Homer we found out this was drafted in French and English at the same time with competing versions.
I defer to your lordship's greater knowledge of the originals versus the translations.
I've been trying to say
And I'm grateful. But, my lord, no, this isn't giving you the answer, but I do hope I'm giving you the answer. Can I take your lordships also to 16035. I'm not sure if your lordships have read the whole section, but the point I make there is that the authors here suggest that 15C refers only to compensatory damages, and it could be argued that non-compensatory damages, in particular exemplary damages, are not a matter covered by Article 15. And I go one further and say, well, we're not looking at exemplary damages. We are looking at penalty interest. All the more so in that regard, I would submit.
Somewhat oddly, the footnote for that, 86, states this reflects the fundamental refusal to accept real punitive damages in continental European legal systems. Which might be added in brackets, not in Spain.
Well, except in Spain, where
It's not
the damages aren't punitive, it's the interest.
But that's why remedy is important.
But remedy, I say, and this is why I'm taking your lordship, this is limited to restitutionary compensation.
Yeah.
We haven't got the different language versions. I'm being asked to point out to make a point in relation to the different language versions. I think given that your lordships don't have the different language versions before your lordships, I won't trouble you with that at this stage, but may I reserve my position and possibly come back to your lordships on it. So, my lords, on this provision, we say that the scope of 15C is not such as can be said as to include the penalty imposed on an insurer, not tortfeasor, for procedural default. And then lastly, 15D, you'll recall that this was considered by Lord Justice Floyd at paragraph 139, which I've already taken your lordships to, and he ruled there that the words should be given no wider effect than the language suggested. I invite your lordships to bear in mind again the extract from the Travo, which we've summarised at 12C, which I hope your lordships still have open as a skeleton argument. Namely, that this too refers to forms of compensation. I submit that at the same time, it makes clear that this clause, insofar as it is mandated to ensure the provision of compensation under this provision as a matter of the substantive applicable law, that is to take place within the limits of its powers under its own procedural laws. So, drawing all that together, my lords.
Why is that? Why are those early words necessary? If matters of procedure are excluded anyway. Sorry to ask you such basic questions.
Not at all, my lord. First of all, we're not basic, and secondly, that this case endlessly throws up more questions than it's as we go along. Sorry, may I just find the article? So within the limits of the powers conferred on the court by its procedural law. So, for example, my lords, if we look at one of the recitals, if I can take your lordships to recital 32, it may be that the intention behind recital 32 informs the provision at the beginning of 15D. I agree that it would be arguable that might or might not be a limit of the court's powers conferred by procedural law as opposed to substantive law of public policy. But I raise the question, I'm not sure I can answer it. I now have the answer, I think. Mr. Mead, who sits behind me and is affectionately known as Maestro in our chambers on issues of international law, asked me to make this submission, which is that essentially it's there to ensure that if the foreign law provides that in these circumstances you must, for example, grant an injunction, but an injunction is not permissible as a matter of the lex fori, then you're caught by that provision, and that is why it's there.
That's activist. There's a reference to that in activist, I think. In the passage that you took us to, I think it's activist.
Yes.
Where I think Lord Justice Floyd says these may be remedies, these are things that are not known to the court.
I think that's right, my lord.
Thank you. Thank you, Maestro.
My lords, I was going to pull all that together, but I'm not sure it's necessary. I hope that the thread of our submissions have emerged clearly from that. But essentially, we say this is expressly excluded as an issue of procedure, and it does not fall within any of the categories included as being a matter of the substantive applicable law under Article 15. And by both routes, we get to the same answer. And for those reasons, we invite your lordships to allow the appeals to rule that penalty interest is not an issue of substantive applicable Spanish law. It is an issue of procedure within Article 1.3, and therefore the applicable substantive law shall not apply. And therefore, it is wrong to exercise the English discretion, now fettered by Rome II, to allow it back in as an issue of procedure. Only one procedural rule must apply, and that is the law of the forum. My lords, may I turn...
Can I just ask you on, because I think it was a point that Mrs Justice Lambert made specifically. The law of the forum does include a very large discretionary provisions in 35A and 69. I mean, I appreciate to mimic the effect of it, but if one's having regard to the fact that overall you're looking to deal with like cases alike, then that's a permissible approach. What do you say the fallacy is with that?
So I come back to the point I made earlier on. Perhaps I didn't make it well enough, but my lord, we say that the discretion as a matter of English law is wide, but since the enactment of Rome II, it is fettered. That discretion has to be exercised judicially. Rome II is retained legislation. The discretion has to be exercised in a Rome II case consistently with Rome II. If Rome II stipulates that an issue of procedure is a matter for the lex fori, The discretion has to be exercised in that way. That's what we say.
Thank you.
In that context, in that way, doesn't mandate a particular exercise of discretion. It just provides the context within which the discretion is to be exercised, doesn't it?
I think that's fair, my lord. In my initial submission, I put the issue as whether the exercise can or should be exercised inconsistently with Rome II. And I certainly submit that insofar as the exercise must be, the discretion must be exercised judicially, it must be exercised consistently and in accordance with Rome II.
And can I just ask this follow-up question just on the final bit on the assuming you're right on substantive. If you look at all the authorities that are before us, some may have found it substantive, some may have found it procedural, but they've all ended up giving interest. And therefore, I mean, wouldn't you say that's a sort of some indication of where justice lies?
No, my lord. That is a jury point. Your lordships have to approach this as a pure matter of law. I say that those previous decisions, and they haven't all done that, so trope is the exception.
On a pleading point, as it were. Yeah.
And in any event, this is a point which your lordships must decide untainted. You're not bound by first instance decisions. You shouldn't be influenced. I say
of course
they're all
not bound.
The English court, in a claim brought in the circumstances of these claims in England, is seeking to provide full compensation.
Indeed. Rome too seeks to provide full compensation.
Yes, well, but we have a perspective on what full compensation may involve. What would be the position under Section 35 if a judge decided that the application of the Spanish substantive law, lex causa, led to only 50% of what we would regard as full and proper compensation, either because Spain adopts its tariff version or for whatever reason? It could be any other country. The possibilities are multitude. What happens if the English court gets to the end of the calculation suggested by the lex causa and decides that that is only 50% of what full compensation should be? What can it do with Section 35A?
Nothing, my lord. You cannot make up what you perceive to be a shortfall as a matter of your own substantive law if Rome II determines that you have to apply Spanish law. It's harsh. We all know it's harsh. And in our perceptions, all of our perceptions, it does cause as what we perceive to be injustice. But at the European law level, there is the overriding objective for consistency. And so it is what it is. But what this court cannot do is form the view that Spanish law is unfair and then use a procedural power to remedy that unfairness when it is mandated to apply Spanish law of substance but English law of procedure.
So is the answer this, that if you have the misfortune to have an accident, and I'm not being tendentious about this, it's meant to be entirely neutral. If you have the misfortune to have your accident in, let us say, Spain, you may simply find that you are subject to a regime. If Spain is the lex causa, you may simply find that you are subject to a regime which gives you more or less than if you suffered the accident over the border in France or Gibraltar, let us say.
The answer is precisely that, my lord. And it can cause unfairness, and I do not seek to persuade you otherwise.
But it's more acute than that in this particular case, because suppose, for these purposes, Spanish law gives you half, then if we'd have been in Spain, we'd have got the other half back through the fact that there hadn't been this payment on account.
That is a consideration, my lord, which is for the claimant to take when it chooses the forum in which it sues. And And that is the point. The claimant has a choice, and the claimant should be properly advised as the consequences of making that choice. And I accept the point your lordship makes, but that is the consequence of the law.
Thank you.
Lords, may I turn to subrogation?
Could you just
Lords,
give
the
me a
issue...
moment- give me a moment while I just make a quick note of that.
Certainly. And Lords, the issue here is which law governs the issue of any subrogation of the claimant's rights and the conditions for the exercise of the subrogation. Is it the law applicable to the tort, that is Spanish law in our case, and that is our case, it is, or is it the law applicable to the insurance contract, that is the respondent's case? Since these appeals were underway, there has been a decision of the Court of Justice of the European Union in the Fonds de Garantie case. And we say that that follows the previous decision in the case of Ergo, on which Mr. Mead relied in the case of Sedgwick below, and it determines the matter beyond any doubt in our favour. And it determines that the law of subrogation and the conditions under which the rights of subrogation can be exercised are the law of the tort, Spanish law. And by way of an aside, it was no doubt for that reason that in one of the cases, in the case of Nichols, the defendant had taken the point in the pleadings, and Mr. Archer immediately amended to bring in the insurer's second claimant, which is permissible because then the separate cause of action is brought by the insurer in addition to the claimant. Whereas in Woodward, the claimant didn't seek to do so. Mr. Chapman below ran the same arguments. They were rightly rejected by Her Honour Judge Walden Smith, and although there's no appeal on that point, the appeal comes before you because of the outcome in the case of Sedgwick. Now, if I can take your lordships briefly to the judgment of Mrs Justice Lambert first, and my lords, this is Core Bundle 187, paragraphs 55 onwards.
So, can I just see the practical effect of this is that the insurers then should bring their separate claim for these damages?
Precisely. Yeah. And they cannot bring it through the claimant because under Spanish law takes the view that if a claimant is recovered off the insurer, the claimant hasn't suffered a loss. My lords, the section on subrogated losses begins at paragraph 55 under the separate subheading. The core of the judgment is from paragraph 67 through to essentially 72. May I invite your lordships to read those 5 paragraphs, please?
67 to 72.
72, please.
67 is nor does the defendant's expert.
That's it.
Thank you.
Or 66 if it helps to put it in context under discussion conclusion.
Well, although you didn't ask us, 73 is also relevant, I think.
I'm very happy for your lordships to read right through to the end. You'll see that after 73, she refers to the case which Mr. Mead relied on. That was the then leading case, Ergo, which she cites at length. And I wasn't proposing to take you through all of that because it's dealt with and interpreted by the Fond de Garantie decision of the Court of Justice. And the judgment is a little bit dense in itself.
Which Ergo? Or the
Ergo. The Fond de Garantie is very clear, but
okay, well,
the Ergo decision.
so
But it's been superseded by, if I can put it like this, can I take your lordships to Fond de Garantie, and then if need be, I can take your lordships to Ergo?
yeah.
My Lord, you'll have seen that the point raised by my Lord Justice Dingemans as to what's the position in Spanish law, that was dealt with as an agreed point in the evidence by the Spanish law experts. That's paragraph 68 of that passage that I invited you to read. So if we can go to the Fond de Garantie case, please, my lords. This is authorities bundle tab 14. And this is case C264 of 2022. It's reported in the International Litigation Procedure Reports, volume 24 at page 597. And my lords, to set the scene, can we start at page 603 of the judgment, of the report, I'm sorry, paragraph 9 of the judgment. Essentially, the facts were these, and this is picking it up at paragraph 9. We have a 2010 accident in the sea off Portugal. You'll see from paragraph 10, the French victim claimed damages in France from the Fond de Garantie, and the settlement was then approved in France. And for your lordship's note, although the Court of Justice describes the Fond de guarantee as an insurance company. It's paragraph 2 of the judgment. It seems to us it's more akin to a CICB than an insurer, but for subrogation purposes, the point makes no difference. Because at paragraph 11, what the fond de guarantee does is it then brings proceedings against the insurer of the tortfeasor, Portuguese insurer, before the Portuguese courts. The Lisbon court, at first instance, dismissed the claim on the basis it was statute barred as a matter of Portuguese law. That's paragraph 12. And at paragraph 13, you'll see that the fond de guarantee then appealed, asserting that the applicable law was French law with a different limitation period. And paragraphs 15 to 16 over the page summarise the question that was then referred by the Lisbon Appeal Court to the Court of Justice. In essence, the issue I've identified for your lordships today was the subrogated claim to be determined, was the issue of subrogation to be determined as a matter of the applicable substantive law of the tort.
Can I just, sorry to interrupt, checking on that paragraph 2, they describe the other insurer as an insurer, but not the fond de guarantee, and Reaseguros SA, an insurance company. Because fond de guarantee has never been an insurer.
Oh, I'm sorry, I misread that. You're quite right, my lord.
Okay, sorry.
I'm so sorry.
That's fine. It's just like
you're quite. I've obviously read that too fast. The point holds good. It didn't, because the point I was making is it didn't appear to be us, an insurance company, but it's the same principle. They are exercising a subrogated claim, having settled the claim in France. Thank you, my lord, and apologies for that. 18 to 20, paragraphs 18 to 20. Here the Court of Justice started by considering the proper law and the issue of limitation under Article 4.1 and 15H of Rome 2. And the court held that the law of the place of the tort regulated the limitation period. So Portuguese law applied. At paragraph 21, it turns to consider Article 19, issues of subrogation. And it describes at paragraph 21, in the middle of that paragraph, that article thus distinguishes how the article draws a distinction between two relationships. On the one hand, between the claimant and the insurer, the claimant here being the creditor and the insurer being the third party. And on the other hand, between the creditor and the debtor being the tortfeasor. And the key paragraphs follow. First of all, and perhaps again, it's easier if I just invite your lordships to read 22 through to 25, please.
It's the last sentence of 22, isn't it?
Precisely, my lord. Well, it's also in the middle of that paragraph, my lord. Article 19 of that regulation provides that the issue of any subrogation to that victim's rights and the conditions for the exercise of that subrogation are governed by the law applicable to the duty of the third party to compensate that victim. But, that sentence as well as the last sentence, precisely. Sorry, did my lord say paragraph 22 or 24? We may have been at cross purposes.
In other words, the law applicable to an action by a third person.
Exactly, my lord. The same point is picked up. I thought you had said 24.
No, I
I'm sorry,
said 22 because of all these various formulations. That was the one I understood. So that's why I was rather hoping that would be the key bit.
It is the key point, and it's taken up again at 24.
Yeah,
I'm sorry if I confused
No,
you.
I get that.
And I imagine there's now a limitation period that is relevant in all this, is there?
Yes. Yeah.
Otherwise, the point's not worth arguing about.
But it's also not. It's also pertinent to bear in mind that the insurer, having not brought the claim correctly, penalty interest has been claimed on the subrogated claim as well. My lords, we've also, there's further reasoning in paragraphs 29 to 31, so to complete the exercise in one go, may I invite your lordships to read those paragraphs as well, albeit the substantive points have been made in the passages you've just read.
Well, paragraph 29 on its face makes complete sense, but is concerned very much with the limitation position.
My lords, the last sentence of paragraph 31 puts it pithily. The debtor ought to be able to rely against the third-party subrogee on all the defences available to him or her against the injured party, in particular those relating to the application of the limitation rules. And so we say here, not in relation to limitation, but the ability to bring the claim under Spanish law. So translating that to this case, because Spanish law requires the insurer to bring a subrogated claim in its own name, and because that did not happen in Sedgwick, although it did in Nichols, as it happens, Spanish limitation would bar the claim now. The learned judge below, with the greatest respect to her, fell into error. Ergo has been clarified or further interpreted by the Court of Justice in the form of guarantee case in the way set out at paragraph 24 of its judgment, consistently with our submissions below, and we allow you we invite you to allow the appeal on this issue and rule that the claimant cannot herself bring a claim in her own name for the subrogated losses.
And have I got this right? That point's limited to Sedgwick.
Absolutely, my lord.
And to the 30-odd thousand or something.
Something like
Yeah,
that. Yeah. My lord, I wasn't proposing, I don't think any of us are proposing to deal with the fallout in terms of pounds and pence, but to invite your lordships to give rulings of principle on these three issues, leading us to then sort out the consequential matters.
Yeah.
My lords, unless I can be of further assistance and subject to my turning around, may I just do that?
Of course.
And it did. I'm grateful. Where's that? 16. Could I invite your lordships, in answer to the question I wasn't able to answer earlier on my feet on the what page? 61. Yes, tab 16 authorities bundle, please, my lords. This is the point about whether activists went to the Supreme Court on other issues. I still have to check Lord Justice Dingemans' points about to what extent it dealt with the Rome 2 issue. But you'll see at footnote 83 on page 61, second page into that tab, and this is Dicey 16th edition. Footnote 83, you'll see the reference to the Supreme Court decision.
Yeah, I'd still like to see it because the law report says it didn't appeal. And it's not unknown for some of these footnotes to be inaccurate.
I will get copies of the Supreme Court decision.
The Supreme Court decision is actually on Westlaw as well, so it doesn't appear that there was an appeal.
Yeah, bizarre, isn't it? Anyway, thank you very much indeed. That's very helpful.
My lords, unless I can assist further, those are my submissions.
No, that's everything. Thank you very much. Thank you very much for stalling. Mr. Chapman, it's up to you. You can have 3 minutes, or you can start at 2 o'clock.
I think it probably makes more sense to start at 2 o'clock.
Fine. All right, well, we'll come back at 2. Thank you very much.
Organising people.